Hello, ladies and gentlemen, and welcome to the second session in Digital Europe's Tech Allies series, examining EU and US relations in the context of digital technology. Today, we're talking about data flows and the prospects of a new agreement to replace Privacy Shield, the data transfer scheme that was ruled unlawful last year by the European Court of Justice. My name is Pete Swaby, and I'm your host for today. I am the editor-in-chief of Tech Monitor, a website for technology leaders from the publishers of the New Statesman. In a little while, I'll be moderating a panel discussion with policymakers and representatives of business on the state of data transfers and what's at stake in the ongoing negotiations. Before that, I'll be handing over to Digital Europe's Director General, Cecilia Bonefeld-Dahl, to introduce our keynote speaker. But first, some tips on using the conference platform you're looking at now. To the right of the screen, you'll see a chat function. Please use that chat function to submit any questions you may have to the speakers and panelists, or if you just want to comment on anything you heard, or to contact Digital Europe and the team running the event. Keep an eye on the poll tab, which we'll be using to gauge your views during the panel and also to collect your feedback at the end. The People tab allows you to see who else is watching this session. You can chat with participants and even set up one-to-one video calls. And please stick around after the panel when we'll be opening the networking area, or you'll be paired up with another viewer. So please give it a try. You'll never know who you might meet on there. Lastly, if you are posting about the event on social media, please use the hashtag #TechAllies. And with that, I'd like to hand over to Cecilia.
Thank you so much for being here, Pete, and for moderating this session. So I would say this is the second of 3 events on US and data flow and EU-US collaboration. Last time we heard about the Technology Council. We discussed some of the issues that needs to be solved, amongst others the Boeing Airbus tariffs, but also where can we really collaborate in cybersecurity, artificial intelligence, and of course in data flows and data governance. This time we're going to speak about data flows, but let me start by introducing, of course, myself, the organization, and a study that we did as an intro for this great event. So next slide, please. If you look here, we represent around 35,000 businesses all around Europe. We have 40 organizations represented in 35 countries. And we really aim for a European Union that nurtures and supports the digital technology industry and really provide the economic benefits to Europe and, of course, to the international partners that we have. And not to forget, of course, the EU-US transatlantic relations. Very strong relationship, both in policy, in security, and, of course, in trade. We all know that the future trade agenda will be all about data. Data is increasingly creating value all across different sectors. This is not a digital issue, and let me return to that. Let's look at the next slide. So this time, as I said, it's about data flows, and we will look at the consequences of the fall of the Privacy Shield, but also what can we do in the meanwhile while we are waiting for the next version of the Privacy Shield, and hopefully this time one that will stay, because this is the second time. There was also the Safe Harbor, now the Privacy Shield that fell. And how do we make sure that one of our absolutely biggest partners, both in trade and in digital, actually that we can transfer data across the Atlantic in the meanwhile? And of course, not to forget, on the 3rd of June, we will be discussing about the digital rulebook and how can we align our regulatory compliance, our standards, etc., and a variety of areas in digital. Okay, let's look at the speakers that we have here today. So in a minute, of course, I will introduce the Vice President, Jourová, maybe the grand lady of data flows, I would say. Let me return to that. But also the great panel that we have. We have Bruno from the Commission. We have Alex Greenstein, who's Director for the Privacy Shield. We have Irina from HPE, very experienced lady in policy from private sector, and Jussi, who represents the whole industry, digital industry and engineering industry of Finland, and of course moderated by Pete. So let's look at the report that we did. We surveyed 300 businesses in 25 countries, collaborating with Business Europe and ESEA, ERT, and others. And let's look at what we actually found out around data flows. So, as you see here, nearly all companies that we surveyed are using the standard contractual clauses, meaning the other data transfer mechanism than Privacy Shield, to transfer data across the Atlantic. Actually, this is international data flows, not only for the US. As we see, 70% of the SMEs that we surveyed are actually using this as a mechanism of transferring data. So this is definitely not a digital issue. We have looked at car manufacturing companies, we have looked at industrial companies, health companies, many other types of companies, and all across the industry, they are actually using data transfers back and forward. Just imagine yourself, you are an SME, you have a branch in US and maybe somewhere else in the world, and you want to send a mail with certain data, research data, or just a mail to your colleague with certain information on a client. There you go. There is a data transfer. Okay, let's look at further where the data transfers actually goes to. So, as we see here, yes, it is an issue for 37% of the companies. They were from the information and media, so from the ICT sector. But this is actually not just after the ICT sector is manufacturing, it's professional services, it's finances, insurance, it's retail. So what we know for sure is that the data, the value creation of trade is increasingly coming from data. It means that you are more innovative, you are faster, you give better services, you're more competitive, the more you use your data to serve your clients, maybe for predictive maintenance of machines, tools, maybe for making sure that your clients receive financial services. So data transfer is something that is cross-cutting across all industries. As you might know, Digital Europe is also representing the manufacturing industry and the health industry. And for health, this is definitely one area where all innovation is linked totally to data. So where do these data, where are they actually transferred? Let's look at the next slide. Well, as we see, EU-US data flows is absolutely the biggest data transfer partner that we have. So hence this event, we simply need to find a pathway to, one, how do we get the new Privacy Shield up and running? Two, this is going to take some time. What do we do in the meanwhile? And therefore, we have brought these fantastic speakers into the studio today, basically to discuss this. I hope that we will have a session. Let's look at the next slide. These are the three overall questions that we will be discussing, and I really hope that we will take the opportunity also for the audience to write your questions in the chat box to discuss and try to really aim to understand how can we find a common pathway? What are the key problems? And what must we learn from last time? And what are the overall timelines, more or less, that we need to aim for? So thank you so much for listening. For now, I would like to bring in the grand lady of data flows and someone who has really been driving this also under the last administration, really being a true believer in the collaboration between EU and US and trying to find a pathway for the data flows between EU and US. Please, Mrs. Vice President Jourová, thank you so much for joining us today.
Thank you very much, Cecilia. Thank you for inviting me. Thanks to Digital Europe, I have a chance to have a discussion with you today. And through Cecilia, I have some history in this, ups and downs. Well, and there is also a big truth that I am a big believer in as close as possible EU-US cooperation. And the trade cooperation indeed is very much dependent on free flow of data. Yeah, so this is all clear. Thank you very much for the very interesting data, which I didn't see before. I think you said we need to find the way for the safe, secure transfers of data between the EU and US. And when I hear myself to say we need to find the way, it's like a deja vu, because this is exactly what I kept saying after Safe Harbor was declared null by the ECJ, and now after the Privacy Shield fell. We indeed have to, again, try to find the way. And this is a very big task for both sides of the Atlantic, for the EU and US, where we see the new leadership, which might start a new chapter in our cooperation on trade, on many other things, on technologies, and also on trusted data flows, which might be solved through or enabled through a new system. The issue of transatlantic data flows is, you will agree with me, not just about the data protection alone, but rather about two like-minded countries working together. And we have seen enough with the Cambridge Analytica case, hacking and data leakage scandals to understand that data protection is not a luxury, it is a must. And you know how much European Union is focusing on protection of fundamental rights in all different areas, including the digital world. So we see that in the cooperation with the US, there is a new chance to set the new dialogue, and also to create the alliance which could be inspirative for the rest of the world. We can see that data protection standards are increasing worldwide. And I believe that the European data protection rules are and might serve as a global inspiration. And democratic countries such as Japan or South Korea are converging with our data protection rules. And thankfully, United States are back as our partner, as I said at the beginning. In my conversations with the Secretary of the Department of Commerce, Gina Raimondo, I got a very clear signal that the data protection negotiations are her top priority. And now we have to see this renewed political commitment translating into concrete solutions. On our side, on the EU side, things are very clear. Any solution that we will agree upon must be compliant with the court ruling in the Schrems II case. Only such solutions can be lasting and offer predictable legal environment for companies on both sides of the Atlantic. We cannot afford to have the new arrangement and new agreement struck down by the Court of Justice of the EU again. We cannot afford to have Schrems III. I believe that as like-minded partners, we should be able to find appropriate solutions, as we have to address principles that are cherished on both sides of Atlantic, which are, for instance, access to court, enforceable individual rights, and limitations against disproportionate interferences with privacy. It should be possible for the US to develop solutions on these issues with a close partner such as the EU. So I remain pretty much confident that the finding solution for our transatlantic data sharing regime with the United States is very much possible. It's our task, it's our obligation, but again, the quality must come before speed. I believe there is now a momentum to work amongst like-minded partners and to reap the tangible benefits of this convergence. This is why the EU continues to roll out an ambitious agenda on international data flows. And we remain open for business, but we are very mindful also of the risks. Data protection and data flows are just one element determining our approach to digitalization. Together with like-minded partners, the EU and the US should intensify our cooperation to address the issues that threaten our shared freedoms and values, including the propagation of hate speech and disinformation, threats to electoral integrity, or the governance of artificial intelligence. Let me conclude with trivia. Together, we are stronger. Rather than seeing Europe as competitor in digital solutions, we should turn the page. The new privacy shield could become a symbolic moment of the renewed transatlantic partnership. Thank you.
Thank you so much, Vice President Jourová. Please allow me to ask you a few questions also. Now with this new Biden administration that I think we're all delighted to see, what are the opportunities that wasn't there before maybe, and how do you see the Commission's strategy? I mean, how do you approach this?
Well, you will hear Bruno Gencarelli, who is exactly in the kitchen of all that. He's cooking with his partners on the US side the possible new product, the Privacy Shield, which will come again and better compliant with the with the EU highest court. What is the strategy? First of all, we have to achieve common understanding of the pillars we have to build the new system on. And the pillars are very clearly stipulated in the ECJ decision. For us on European side, the court decision is a clean compass. And we have to fully respect the decisions of our highest court and ensuring compliance with the decision, because I think the biggest or the essential vision for our strategy is that we have to restate the full legal certainty. I can imagine that for big ones or small ones, and not only digital business, you rightly pointed this out, Cecilia, that this is not about digital business only, this is about many other sectors. So four of them, the legal certainty will be very valuable contribution from our side if we achieve the new system, which will be fully compliant with the ECJ ruling. I was convinced that Privacy Shield was fully compliant with Schrems 1, by the way, but that's new reality we have to face. Then we have to step by step go through all the problematic issues which we see and which should be solved, especially and mainly on US side. First of all, the federal law on data privacy would help enormously. And for that reason, I was lobbying really heavily in the US Congress to see such law. For what I heard from Republicans, well, yes, we will consider that because a fragmentation of our legal framework would not be good for business. And we already see the Californian law and Virginia upcoming law. So this was the response from Republican side. From the Democrats, I heard, yes, indeed, we need to increase the protection of privacy of American people. And so very promising moments I remember, but then when the elections were approaching, the chance was disappearing. So now again, I think that there might be appetite to have the federal privacy law. Also, we have to look into the national security side. And this is what I said to Madam Secretary, Raimondo, that she is on the easier part of the whole thing. The the part of commerce, we were able to come to a very good agreement. But the national security side, this is the battlefield where we simply have to resolve the conflict between the national security principle and the privacy and protection of individual rights of the people. So on that side, there must be done more. We need to achieve better or stronger certainty for the individuals, for the Europeans, that they will get redress in case there is something wrong, and that they will get impartial response about what was happening to my data on American territory. We tried to do that through the ombudsman. It was seen as a weak arrangement. So we have to especially try to invent a more robust set of safeguards on the side of national security and to have better protection against mass surveillance, which is the big elephant in the room whenever we speak about the data flows. So I think the strategy is clear. We have to look into the gaps and find the solutions which will be trustworthy, reliable, which will enable us to set up the new system. And as for the timing, good strategy should have a timing. Here I will reveal that maybe still the strategy is not good enough because I don't know the exact dates. We already resumed the talks, but it will not be just next week or next month. It will take more time. And I said at the beginning, time must not come first. The quality and absolute certainty of the robustness of the system has to come first.
So I hear a little bit that you also see that US is in the same situation as EU. They need to find one way of doing data protection also themselves, right? And hopefully that process will, start again and really accelerate. And then we have the big pillar of legal proceedings and how does it actually give certainty for citizens, and the other one is surveillance. And I'm looking forward to also hear the panel how they see these three aspects of this problem. Do you think there will be like an interim period where we will be more and more dependent on the standard contractual clauses, where right now, the European Data Protection Board is like, we're waiting, and can we get some kind of interim legal certainty so we can act in this environment until the new Privacy Shield 0.2 or whatever it's going to be called will appear?
Well, thank God the standard contractual clauses remained alive. So this is the only choice. Well, of course, there are other possibilities to have to run the legally the data flows or the data transfers. But for the clauses, this is definitely the interim measure for the provisional measure for the period before we have the new system in place. It takes time, I agree. We worked very intensively with the European Data Protection Board because I really tried also myself personally to fine-tune the positions so that we do not come with diverging views and diverging plans which might mislead or confuse the business world. So now we are in the final stretch or final phase of the comitology procedure. In the coming weeks, we will have to decide, and as you might know, the standard contractual clauses will and the rules relating to them will need the green light from all the member states. So this is ahead of us. Rather complex procedure, but it will, I think, be satisfactory solution for this interim phase.
So thank you so much, Mrs. Vice President. I would say you are really at the heart of one of these very complex issues that the digital decade and the century of data is creating. And you should just know that from industry, I mean, for us, we are very interested in getting as you said, a robust framework to share all our knowledge, and also, of course, in finding an interim period, maybe with other legal certainty measures like the standard contractual clauses. And we have tried also to put forward our recommendations on what are these additional measures that we already are working with or could be put in place. So count on us for bringing in both the relationship between EU and US, but also on finding a thorough framework. And please bring us in if you need even more support on this. Thank you so much for your participation in this great event. I'm going to hand over to Pete and to the great people on the panel. Thank you so much.
Thank you very much. And indeed, I count on you. Thank you, Digital Europe. Thank you, Cecilia. To all, have a good day. Bye.
Thank you.
Hello again, and thank you, Cecilia. I'd now like to welcome our panelists for the next session. So please welcome Alex Greenstein, Director of Privacy Shield at the US Department of Commerce, Bruno Gencarelli, Head of the Unit for International Data Flows and Protection at DG Just, Irina Bednarich, Director of Corporate Affairs for EMEA at HPE, and Jussi Mäkinen, Head of Digital Regulation for Technology Industries of Finland. Thank you all very much for joining us. So the objective of this debate is to give our viewers some insight into what's at stake in the ongoing negotiations, in which Alex and Bruno are both directly involved, for a replacement to Privacy Shield, to understand the various perspectives at play, and as we've heard, it's a complex matter, what it all means for businesses, and gain some understanding, if possible, of what might happen next and when, although our previous speaker has given us some insight into that. So I'd like to start with the understanding of the principles underlying the original ruling and how both the US and EU understand its implications. I'd like to start with you, Alex. Last year, as we've heard, the European Court of Justice ruled the Privacy Shield scheme was unlawful in an echo of the 2015 ruling on safe harbor. What was the US interpretation of this most recent ruling? What does it tell you about the EU's approach to data and its approach to international transfers of data?
No, thanks for having me here, and I definitely sort of appreciate the opportunity to speak about sort of the importance of transatlantic data flows and sort of the important work that we're doing right now. And it's yeah, good to sort of be here with Bruno, and because we're working together very closely on this. Just want to emphasize from the outset, I mean, the Biden administration considers finalizing an updated privacy shield to be a top priority. And the Secretary of Commerce, Gina Raimondo, remains actively engaged on this issue, as demonstrated by the conversations that Vice President Jourová mentioned. This is also reinforced by the fact that we have had a joint statement between the Secretary and Commissioner Renders regarding Privacy Shield and are intensifying sort of the negotiations. But yeah, I mean, to get to your question, I mean, we definitely recognize that the Schrems II decision led to the invalidation of the Commission's adequacy determination for Privacy Shield, and that we need to sort of fully address and comply with that decision. And that's what we're working on right now. The situation has evolved since, like, I know 2015 and the Schrems I ruling. And we recognize that we need to look at what we've negotiated and see what else we can do to enhance the framework. And that's what we're doing right now. And this is really an important charge, because these data flows that we're talking about, these underpin sort of the transatlantic digital economy. And so this is a major element of sort of US-EU cooperation. And it's something we're committed to working together with our European partners to restore certainty and predictability to these data flows and the transatlantic relationship.
Is there anything you can share about how, from the US perspective, things have evolved since the 2015 ruling on safe harbor? Viewers might be thinking, did history just repeat itself, and we're going through exactly the same process, and it may have exactly the same outcome, which is to say, an only temporary outcome? Or is there, from the US perspective, some new insight that was gained from the most recent ruling that is being brought to bear in the current negotiations?
Well, no, I think that certainly, like, we've definitely sort of read the ruling quite closely. And I guess I would say, like, I wouldn't view this as sort of a revolutionary idea. I mean, this is sort of it's something of an iterative process where I think that we are sort of getting closer to a full sort of understanding of what the court needs. And then we are looking at sort of how to do that in a manner that works with sort of the US legal system and with our sort of constitution, and also that sort of is done in a manner that still enables the United States to protect its national security and that of our allies. And so I think that sort of like finding a solution that sort of meets all of those needs, I mean, isn't easy, but I think it is something that the Schrems II ruling did give us sort of a better steer on, and that's sort of like what we're working towards.
I'm trying to see if there is, if you can characterize perhaps the difference that from your perspective, what Schrems II revealed that Schrems I hadn't.
Well, I mean, I think, like, it talked about sort of definitely, like, I think of it sort of in a couple of sort of buckets here. I mean, definitely sort of there's questions about sort of redress, there's questions about necessity and proportionality, and those are sort of the two areas that we are sort of focused on, I guess I would say, sort of in our discussions. And
okay.
yeah, so we're looking at sort of what we can do to sort of enhance the framework with regard to those issues.
Bruno, I'd like to bring you in here as well. From the Commission's perspective, the same question again, really. What was revealed in the Schrems II ruling that hadn't been apparent from Schrems I? Is it just a refinement, or have we gained a greater understanding of the way the core principles of the Commission need to be applied through data transfers?
Sure. And first, Pete, thanks for the invitation. Very happy to be here with my co-panelists. Well, Alex has said it all in a sense. Just to maybe for the audience, for your viewers, in Schrems I, we were told by the court, you have not assessed something. And what didn't we assess was the fact that when we adopt an adequacy decision, we have to follow the data. So not only assess the level of protection which is applied by companies in the third country, in this case the US, when processing the data, but also what are the limitations, safeguards that apply when, for all sorts of reasons, legitimate reasons, national security, law enforcement, the authority of the public authorities of that third country need to access the data or seek to access the data held by the importer, the private companies that are importing the data from Europe. So that in Schrems I, the safe harbor was quashed because that was missing from our assessment. Schrems II gave us a mandate, has a much more detailed list of requirements that we have to fulfill. I like the word that Vice President Jourová used a few minutes ago, saying it's our compass. It's a compass, it's a mandate. And therefore, indeed, there are very clear indication on what should be the limitation against excessive interference with privacy in terms of proportionality and necessity. What should be the rights, the enforceable rights individuals should be able to enjoy, and how they should be able to exercise those rights, including through a redress, a certain redress mechanism, a judicial redress mechanism. So those are and if you go to the judgment, you will see that there is quite a detailed reasoning of the court around those points. And then The Schrems II judgment, if you look beyond the privacy shield, is a very interesting judgment. It's the first judgment we ever had, I would say, on data transfers in general. It's a systemic judgment that tells us how we have to interpret and apply certain standards of EU data protection law, of the GDPR, when transferring data towards third countries, not only the US. There's a part of the judgment that deals specifically with the privacy shield, because that instrument became relevant during the litigation. But there's much more than that. And then if you also ask me, because I understand the questions, the anxieties, the concerns, or sometimes also the joy that might have accompanied, depending on how you see this, the Schrems II judgment. And your question is, what has changed since Schrems I? So legally speaking, we have discussed it. But I think that those issues that were felt very much as European issues have now become much more global issues. Questions around privacy, the fact that you have more and more countries around the world that are adopting privacy legislation, modernizing privacy legislation on the basis of quite common principles or convergent principles, but also that very aspect of governance access. And the fact that in our digital interconnected world, it matters. These questions matter. The questions around limitations and safeguards applying when governments of public authorities around the world need to access data. And it is also more and more seen, not only by us, by our Japanese partners, by our US partners, as an important distinctive feature between like-minded countries that share the same values and principles, and other countries, including authoritarian regimes, that might have a very different approach. So all this to say that, while let's not underestimate the complexity of these issues and the balancing between, on the one hand, privacy, and on the other hand, national security is not an easy balancing act in any system, and certainly not in Europe or in the US. As like-minded partners, we should be able to find appropriate solutions on principles that we believe are cherished on both sides of the Atlantic. And once again, this is about access to court, this is about enforcement of individual rights and limitation against excessive interference with privacy. So that's what this is all about.
You mentioned there that this is the ruling gave you a broad guidance on data transfers in the current climate. But we all know that other European legislation, GDPR, has been very influential globally. Do you feel, Bruno, that there is more at stake in this particular ruling than just EU-US data transfers? Do you feel that this will set the stage for not only data transfers with other third countries for the EU, but almost set a framework for other countries, maybe not including the EU at all, to decide how to manage data transfers?
Well, the answer is in the judgment. I think indeed the judgment applies to any transfers from the EU through a number of tools, and we probably will come to our work on certain of these tools, including standard contractual clauses that have been already mentioned by Cecilia and the Vice President. What this ruling is about is actually about, on this I agree with you, an issue which is not only a European issue. It's about how do you protect a right, in this case, the right to privacy, but we can think about many other rights, in a interconnected and borderless world, where, when it comes to data, it takes only a click or two to transfer data to another jurisdiction, to another part of the world. And you can apply the same reasoning to many other fundamental rights. And what this ruling is about, and one might agree or disagree with its answer, but certainly this is the ruling of our highest courts, and we need and we want to fully apply it. This is extremely important for us, and it's extremely important also to ensure legal certainty. But as I said, one might discuss how the court addresses this, but it shows that if you want today to have a credible and robust data protection system, you also need to take care of the rules, the requirements that apply to international transfers. You cannot, especially data processing, which by definition are almost by definition, by nature, borderless activities, it would be meaningless to have rules that apply only within a country or a continent. There is still I think a positive aspect, especially for the audience on this, is that we have now a more and more convergence on how systems around the world regulate data protection, and that offers new possibilities to facilitate transfers. Because if you have convergent rules, it is easier to develop transfer mechanism. That's what we have done recently, for instance, with Korea. That's what we have done not so long ago with Japan, by creating the biggest area in the world of free and safe data flows. We believe that facilitating data flows and developing robust, safe and open data protection rules can and should complement each other.
Thank you. But before we talk a little bit about the business implications of the ruling and what's at stake in looking for a new replacement for Privacy Shield, I'd just like to briefly ask you, Alex, the same question in a way. Do you feel, I know you were involved in the response to Schrems 1. Do you feel this current discussion has a slightly different context? Back then, I suppose, international negotiations about data protection and data transfers was probably a bit of a niche interest, whereas now it sort of carries a much clearer geopolitical weight. Do you feel this current negotiation is on a bigger stage?
Yeah, I think I agree with that. I mean, certainly, the stakes have sort of only gotten higher as everything has become increasingly digital, and sort of data flows are an increasingly large portion of sort of our economies. And certainly sort of the coronavirus pandemic has sort of brought home the fact that we all rely upon these digital services so much for doing things. I guess I would also sort of say that, the fact that sort of the Schrems 2 decision also has sort of brought in or sort of references the standard contractual clauses and other data transfer mechanisms has also made this about more than just sort of I love Privacy Shield and it's a very important tool. I mean, this is about all data transfers writ large. And so that's another important aspect of this. But yeah, it definitely is sort of a saving grace that the SCCs are still viable as a transfer mechanism. But I mean, this certainly is a significant sort of impact on sort of transatlantic commerce, where you have sort of 5,400 companies who previously relied upon Privacy Shield for data transfers and now are having to find other mechanisms such as the SCCs. But then also sort of there's questions about sort of the longer term stability of that. And that's why we're trying so hard to make sure that we get the national security aspects of Privacy Shield right, because that'll provide greater stability for all data transfers.
Thank you. So in our next section, I'd like to hear a little bit from the business community about what the impact of the ruling has had so far. Irene, what can you tell us about what the Schrems 2 ruling meant for organizations like HPE, large transatlantic companies, no doubt making all manner of data transfers, millions of times a second, and how HPE as an individual company has adapted? So what has it been like for your industry, and what has it been like for you as an individual organization?
Sure. Thank you, Pete, and great to be with you today discussing this really critical topic. So before I come to the point on business impact, just wanted to comment from an industry perspective. We're incredibly pleased, obviously, by hearing this renewed impetus in the negotiations, and really great acknowledgement that we actually do need a new adequacy framework as an industry. But we also clearly agree with the Vice President that quality needs to come over speed. And so we're quite realistic that this will need time to make sure we get it right. So the real question, as also Cecilia mentioned several times, is what do we do in the interim? So how can we make sure that using the alternative transfer mechanisms that are available, we actually have a practical solution that is compliant with the judgment? So what is the impact of the current situation, to come to your question? So I'd maybe like to dig a little bit deeper into some of the data points that emerged from the survey that we have done as Digital Europe, along with ERT, some partners from Business Europe and ASEA. And maybe just the 2-3 facts that I wanted to spend a few thoughts on. The first one is that out of the survey, we concluded that only 9% of companies that we have interviewed is actually supposedly not transferring data outside of the EU. What does it mean? I mean, nothing more than what Bruno was mentioning. Interconnected economies do depend on pervasive data flows. So we just must make sure that we have a practical, I'm not going to say simple, but let's say at least practical way to get data across the Atlantic in a lawful, compliant way. The second data point is the realization that the 3/4 of the companies that are actually transferring data do so in more than one jurisdiction. So when we start looking at the new features required by ruling from data controllers and data processors in terms of assessing the level of protection of the country of destination, we already are finding ourselves in a pretty complex environment with several jurisdictions to be obviously assessed. For last point I wanted to stress is that, and again, no surprise to anyone here, 94% of the transfers in our survey are actually transfers across the Atlantic. So definitely I am with Bruno that clearly great work in the alignment of levels of protection has occurred between the EU and other jurisdictions, but probably really the core issue really to be solved is obviously the transatlantic one. Now, on this backdrop, so coming to the cost specifically, so 92% of the companies that actually did undergo a reassessment of how they use standard contractual clauses, so do they need to use supplementary measures to make sure they offer the adequate level of protection to the data they're transferring. So 92% consider that the cost of compliance, it's moderate to high. Now, what does a moderate or high cost of compliance mean? Unfortunately, I'm unable to give you a dollar or let's say a euro estimate of the cost. But maybe what I can do, I can share a little bit more of how we faced from a big multinational perspective, what were the dynamics that to give you a sense of the cost. And then I leave to my colleague, I think he's much closer UC to the SMEs, and maybe he can zoom in on how the SMEs are facing that. So in the HPE case, shortly after the ruling, we obviously established a worldwide compliance program. So pulling into the same room legal, business units, product people, global procurement, and so on. And basically started with impact assessments. The point is to obviously identify the transfers that are, need to be basically supplementary measures. And then we discussed, so first of all, there were two kind of constituencies with whom we worked. The first one were obviously the customers. And together with them, we sat down and decided what were the most appropriate supplementary measures that we needed to apply. Is it encryption? Is it contracts that need to change, procedures, and so on? So far, this body of work took us roughly 6 months. In our case, we're lucky enough not to need outside counsel. And we had the sufficiently specialized data protection officers and enough of them to obviously carry out all of these impact assessments by themselves. However, an additional body of work that actually emerged was with our suppliers, because in fact, we quite quickly after the ruling, we realized that although depending on the contracts we had with our suppliers, they were obliged to notify if they indeed can no longer use the privacy shield, but need to indeed transition to other transfer mechanisms. And actually, we quickly realized that none of them has notified us. So although, let's say, strictly speaking, would not have been our responsibility, but we decided to proactively approach our suppliers and then basically undergo the same process that we've done with the customers, namely sit down, understand what kind of supplementary measures we estimated would bring us up to compliance with the ruling. So as I said, it's quite hard to give you like a real dollar figure or let's say a quantitative assessment, but hopefully this can give already some pointers that the complexity and the cost of compliance is actually on the high end.
Great, thank you, Irina. Before I will bring in Jussi in a moment, but before I do, can you give us any indication, aside from the cost of compliance, what impact, whether you are talking with respect to HPE individually or companies like it, are there any impacts beyond mere compliance costs? Has it prevented behaviors or strategies or innovations that you might already have done, but hesitated because of the ambiguity in the current environment?
Yeah, so I think there are two main aspects probably here. So the first one, it is quite obvious that what is really at stake here, it's the ability to scale European businesses. So, and I have to say that from all the interventions from the Commission, from what we heard from the Vice President, I think that is really well recognized and acknowledged, hence so much effort trying to find, let's say, a slightly easier, if I may say so, transfer framework. So, and Cecilia gave an example before. So obviously, data transfers basically these days touch upon practically any operations of a company. So you have to comply with the ruling. I think what the problem is from our perspective, from a practical perspective, and also is actually the legal uncertainty that we're currently living in. So again, the Vice President talked about the standard contractual clauses that will be renewed, but we obviously also have on the table draft recommendations from the EDPB. And I guess that one thing, obviously, you have a lot of work to do to comply, be it big company, be it small company. But I think the real problem that we have currently is that we are still quite uncertain what is actually really required. And in particular, I'll just, throw to the table one aspect that we could mention many, but obviously Digital Europe in all our papers did draw the attention to the risk-based approach. So is it okay and is it legal to basically take into account the specific circumstances on each and every transfer, as obviously was present and acknowledged by the Commission in the new SCCs, or as the EDPB recommendations, draft recommendations are saying, you should not be doing that because this is considered as being a subjective assessment, basically, for example, the likelihood that even business contact data, are they likely or not likely to be accessed by surveillance authorities? So if there is one plea to conclude on my end, if there is one request that we would make in this interim phase, it's, legal certainty regarding this supplementary measures. It's something that would help the business really tremendously.
Thank you, Irina. Jussi, as Irina mentioned, many of your members of the technology industries of Finland, as well as digital companies, are smaller companies and non-digital companies like manufacturers. And as we've heard, this is not just about the tech giants. This is about smaller companies too. So, what, from your perspective, has been the impact for those among your members who are smaller, non-digital native, we should say, companies?
This is a very good question indeed, Pete. And we have we're a national trade association having 1,600 members in various areas of technology, including heavy industries, manufacturing, etc. And 1,500 of them are SMEs. So by SMEs, I would mean companies without their own legal departments, let alone DPOs, and they consider themselves of manufacturers of different industrial appliances and pieces of machinery, and not regard themselves being active in data business. But our member companies are doing global expert business. Not only there are big experts to some European countries like Germany, but also to outside the EU. And the ability to effectively process key business information, such as information concerning customers, their contact details, ability to share data between the company and their agents. And if you have a little bit bigger company, then perhaps questions such as how to pool resources and how to place the skills base and develop the skills base globally are the questions that these companies are pondering. And you discussed with Irena the cost of compliance, but we are wondering with our member companies an ability to comply at all to these requirements. And we have paid most attention to the EDPB guidance that also Irena mentioned. And the most worrying aspect is the latter part of its Annex 2, where there are listed some supplementary measures in order to bring the level of protection to a essentially equivalent level of EU data protection law. But then there are some couple of examples where the Data Protection Board does not find any effective measures to these cases. And these are basic business cases where you store data on a cloud service and then access it from various jurisdictions around the world. And these are plain necessities for our member companies to carry their business and prosper. And they have, it's not about how to adapt measures, but how to keep some legal measures and supplementary measures, but how to keep your daily business going in order to employ these employees and skilled workers that these companies need. And these are the kinds of questions. So it's not a matter of how to comply, but how to carry on your business and evaluating the degree of risk of perhaps not complying with all the requirements.
Great, thank you, Jussi. I'd like to move on now to a discussion of the negotiations themselves. Before I throw back to the panel, I'd like to invite our viewers to look at the polling section. Hopefully you will there see a polling question, namely, how confident are you that a lasting solution to the issue of transatlantic data flows can be found? Are you very confident, somewhat confident, not confident, or not at all confident? And please give us your answer to that, and I'll come back to that in 5 minutes, and so we can hear what the views of our viewers are. But let's talk now about the negotiations, the ongoing negotiations, what's at stake, and what insight we can glean at the possible outcomes. Alex, the Schrems II ruling was based on the court's interpretation of some quite fundamental characteristics of the US privacy and data protection regime. European viewers might be wondering, is it possible to find some kind of new outcome for the current negotiations without some fundamental changes on the US side, and, for example, a federal privacy bill?
I just wanted to address some of the other, concerns that sort of were raised by industry colleagues first. I mean, we definitely hear that there is a great deal of concern about sort of the uncertainty that this is having an impact on companies on both sides of the Atlantic. And this is something that we are committed to working through and addressing and trying to sort of restore stability for these very important data transfers to happen. For the US part, I mean, we have back in September, we put out sort of a white paper about sort of US practices in the national security space with regards to sort of surveillance. And our hope is that can help companies make that risk assessment regarding sort of the risk of sort of their data transfers being accessed by the government. I mean, but we do recognize that that is sort of a not a perfect solution to this. And that's why we are very much focused on reaching a positive outcome in our negotiations with the Commission on an enhanced privacy shield framework. But sort of turning to the question regarding whether or not sort of US domestic privacy legislation would impact on sort of the negotiations. I mean, I think that that's something that I would say personally that sort of I would support. And I think that it is good for the United States to do separate from Privacy Shield. But I mean, I don't see sort of federal privacy law as part of the immediate solution to addressing Schrems 2, because Schrems 2 is sort of narrowly focused on the national security and government access to data issues, and did not sort of opine on sort of US protections for privacy in the commercial space. And so the strong sort of enforceable commitments and protections the Privacy Shield provides for data transfers in the commercial context remain effective, and I think sort of meet the needs there. It's sort of, so that's why we're focused on sort of the discussion around national security, which is happening in the Privacy Shield lane.
Gotcha. We have a question from our viewers. Not sure if this is a question best for Alex or Bruno, but I will ask it nonetheless. Matti Neustad Story, the legal director of NetApp, asks, would US federal privacy law be sufficient if it did not address Section 702 issues? Because it seems highly unlikely the US will remove that. Now, Alex, can you enlighten us on Section 702 issues or address that question? Or is it better for
I mean, it's sort of again, this is sort of a question sort of about sort of US domestic privacy legislation. I mean, I think most of sort of the pieces of privacy legislation that have been discussed on the Hill are focused on sort of privacy in the commercial context, and don't sort of touch on sort of authorities for government access to data in the national security realm, which is sort of what 702 does.
Gotcha. Another question from the audience, from Pascal Albrechtskirchinger, head of the Brussels office at ZD. Apology, Pascal, if I mangled your surname there. To Bruno, how far would the US have to move in order to make the new shield, quotes, fundamental right safe?
Can you hear me? Yeah. First, on this question of the federal privacy bill, because of, I think also the Vice President mentioned it before, nobody thinks that the federal privacy bill will resolve the issues we have to specifically address following the court judgment, because the court judgment, as we have said, concerns the way intelligence bodies, if you want, NSA, CIA, etc., can access data. And that's not something that a federal privacy bill that deals with how companies process data, protect data, how they collect data from users, from consumers. That bill will not deal with that. But still, and I think also that's what the Vice President said, if we look at, if we try to look this in a broader perspective or in the long run, it is clear that a federal privacy bill would strengthen the foundation on which any new arrangement we would conclude with the US would be based. Because let's not forget why we had a privacy, first a safe harbor and then a privacy shield. It's because of the absence in the US of a overarching privacy legislation, and therefore the need to construct something ad hoc to fill those gaps and add protections to that arrangement. So I believe that in the medium long term we would, and here we all want, and everybody wants a long-term sustainable solution. It would certainly benefit from that type of legislation. Second point, well, indeed, I agree with Alex. I mean, the US will adopt that legislation or will not adopt that legislation. First of all, I believe because they need that legislation. That's also a big change in the transatlantic, but I would say in the global conversation. When we started with the GDPR, we were a bit isolated. At that point, privacy was considered by many of our partners an outdated concept. I remember when I was going to the US, why are you doing this? You don't listen, you don't hear that anymore. Everybody agrees that privacy is actually one of the key issue of our time, and how to effectively protect privacy. And I think it's good, and it can help the fact that we may have more common grounds now that we had them we had a few years ago. And what I am also observing, and that's interesting for me because I've been following closely and involved in the GDPR process, is that the US is today facing similar issues that we were facing when we decided to propose and push for the adoption of the GDPR. Fragmentation of its legal environment, with, they have been mentioned, California, Virginia, but many other states adopting privacy legislation, sometimes comprehensive legislation, sometimes legislation on certain aspects, and then the need to have a county-wide, US-wide framework. And then the issue that, I mean, I think the demand for privacy is certainly strong in the US, as it is strong in many other parts of the world. Consumers want to be, and citizens want to be sure that when they share the data, this is done in a way that protects their rights as consumers, but also the rights as electors and the rights as citizens. So I think that's the bigger picture, and I think that bigger picture is important. What the US have to do? Well, as I said, we have a number of requirements. We need a redress mechanism, which delivers the same type of redress as a court will do, with the same type of independence, impartiality, and binding powers that a court has, so that when individuals whose data is transferred to the US would have issues or claims, would need they would be able to bring them before a body that can adjudicate those claims, and if they are founded, then require, for instance, the data to be deleted or to be corrected. We need safeguards that are enforceable, therefore that are invocable by individuals on the type of limitations that apply when national security authorities want to access the data, and that are equivalent to the principles of necessity and proportionality. How to do that? There are many ways to do that, and that's what these negotiations are about. And you will understand that I'm not going to enter into the details of the negotiation, but it is clear that we have a strict mandate and a complete mandate, and we will need to fulfill all those requirements. And this is not about choosing whether we like more one part of the judgment rather than another part. What also the representatives of the business community have said here is that they expect, and I would say they deserve, legal certainty, and that legal certainty will only be offered by an arrangement that fulfills the requirements of the Schrems II judgment.
Thank you, Bruno. I'd like to ask those business representatives now, what are you hoping will be the outcome of the current negotiations? What are your top priorities, and how confident that those will materialize? I'll just start with you, Irina.
Sure, thank you. I mean, as I said before, from a Digital Europe perspective, our number one priority it is to have a new framework in place. I mean, that's very obvious. However, it is very clear that it needs to address the two main problems that have been identified in the ruling. So judicial redress, as we already discussed, and surveillance authority access to data. So I guess from our perspective, again, I would like to reiterate that we would welcome to wait to have something that really does address two very intricate problems, to make sure that then we have a solution once and for all. Now, in the interim, again, what we need, obviously, we're really impatient to see the new SCCs when they will be ready. Because we were, from a Digital Europe perspective, very reassured, we have to say, by the draft that the Commission put on the table. In particular, the risk-based approach, and basically the fact that it is aligned with the GDPR in terms of requirements and expectation is basically what we felt is very rational and very pragmatic. On the other hand, there were a lot of concerns with the draft EDPB recommendations. I would maybe just touch upon really quickly about the encryption point that I think has been raised and debated quite a lot already in a lot of fora. But fundamentally, what it currently is on the table suggests that regardless of the circumstances of each and every data transfer, there is a default assumption that surveillance authority may access the data that has been transferred. Hence, we must have this data encrypted, and also on the receiver end, basically the data must be unreadable. So basically the question that we would have, what is the point then of transferring data if the data can't be read? So again, I guess if I may make a final comment on this, our desire from a Digital Europe perspective is a harmonized approach, certainly a concrete approach. So as much guidance we can be offered how to practically go through the steps of analysis that we must make, that's what we need. We need it, again, be it big multinationals with armies of lawyers, and even way more the small and medium enterprises that have nothing to do with digital, but yet obviously communicate through digital means. And maybe one final point. So we did start last week, first, touches of enforcement, I believe, in Portugal. When the, enforcement will come in at scale, what we will basically need, it's a harmonized approach to the extent possible. Because obviously, if the data processor and controller are required to make an assessment of the legal framework of a third country, well, then if we start to have already bottom-up assessments and then also unharmonized enforcement, is going to bring basically a total chaos to the market.
Thank you, Irina. And Jussi, to close, what are your members hoping for, and how confident are you that outcome will materialize?
I think it's quite clear that they are. Our members are asking for predictability and clarity, and these machinery businesses are not deep experts in intelligence practices of third countries, and are not in a position to, in any way, to evaluate that situation. And perhaps I would like to ask that what keeps troubling me is that the way the European Court went to the path of the intelligence issues. And I would like to ask whether we have a sufficient shared base for good intelligence practices, even in the European Union, let alone globally. So, and as Bruno mentioned, that the Commission is having these discussions with US and Japan and other countries on bilateral basis. But shouldn't we have then a multinational shared base for good intelligence practices in order to have lasting solutions?
Is that a question for Bruno, maybe?
Well, thank you for that. It is increasingly a global issue, and therefore global issue also requires a global solution. As I said, it is also an issue which is felt increasingly by a number of countries as a decisive factor, sort of dividing line between certain like-minded countries that share a number of values, of principles, and other countries that might have a very different approach on this. So it's not surprisingly that a number of international organizations or fora, I'm thinking about G7, I think about the OECD, which is developing actually what you are mentioning, a number of trying to develop a number of common safeguards that are shared by its members, that a number of organizations and fora are looking at this. And we are certainly very much welcoming it. It doesn't replace our bilateral work, because the level of detail and the level of safeguards we need to adopt an adequacy decision will, I think, never corresponds to what you generally find in more global or multilateral instruments, which are quite high level principles. But of course, that can help. Let me maybe recall also what an adequacy decision is and why an adequacy decision is subject to a strict, rightly so, a strict standard. An adequacy decision, and you don't have a lot of many examples of that sort in the EU legal system, is basically a decision, a measure by which we assimilate, for the purpose of data flows, a third country to a member states of the Union, because we allow the benefits of the internal market, free flow of data between the EU and that third country, as it is allowed between member states of the EU. With, of course, one major difference is that we allow that with a third country that, of course, doesn't have and will never have the same rule or the same legislation, the same case law as we have. And therefore, the need to have that, to fulfill that standard of essential equivalence, which is not identity, but it's a high level of similarity. So that's why adequacy will continue, I think, to be a process that will have to be carried out separately and with a level of a high level of detail and commitment on both sides. But we certainly welcome the fact that there is an attempt at international level, not only to bring that issue, but to underline the principle, the safeguards that united us as like-minded country, and also to identify some best practices, because there might be many different ways to comply with the principles of proportionality, necessity, which many different ways in which you ensure effective.
Thank you, Bruno. I do have to wrap up now. Before I do, I'd just like to share the results of our poll. The question was, how confident are you that a lasting solution to the issue of transatlantic data flows can be found? 13% were very confident, 59% effectively were somewhat confident, 26% were not confident, and 2.2% not at all confident. Alex and Bruno, any quick reaction to that? Oh, we can't.
Yeah, no, I mean,
you are the American, so no, you are the American, so you are the optimistic.
Yeah, no, I mean, I think that is sort of like, a good indication. I mean, that people are optimistic that we can reach a deal on this. And I think sort of like Bruno highlighted there, I mean, we are sort of like-minded on a lot of issues that sort of underpin this. And I think that sort of we're closer than people think on these issues. And I think that it's sort of like, a matter of, and this is the one sort of upside, is that it has gotten us talking about these things more concretely and identifying sort of best practices. And I think that sort of, the work that Bruno highlighted at the OECD and other fora is really important to, bringing us together to talk about sort of what are best practices for like-minded democracies, and also recognizing that sort of the things that the United States and Europe does in this area in terms of restraint on government access to data stands in stark contrast to what other countries and authoritarian states do in this area.
Thank you, Alex. Now, to close off our panel, I'd like to ask Cecilia to join us again to make some closing remarks.
Thank you so much. Great panel. I've been listening in all the way. First of all, it's extraordinary to have you great people talking on one of the biggest challenges of the digital decade. So without this, we wouldn't move forward, and we really need that. We heard Irina really talking about this is not an easy task, and it's not small compliance issues. This is really fundamentally difficult for companies to operate in. And you see talking about 1,500 SMEs who are, if the big ones are struggling, they are even struggling more on this legal certainty. As Alex said, there are two things. There is the whole proportionality of access to data on the surveillance laws, of course. There is also the redress that has to be kind of addressed and figure out how to go about that. As Bruno also said, it's quality over speed here. It's not an easy ticket that they enroll and take that they have after this Schrems ruling. And you can't pick and choose here. They need to live up to all of it. And we know that it's going to take time in businesses. So what do we do in the meanwhile? That's the big question. And that is where we also lean to finding a good solution, of course, with standard contractual clauses. And hopefully we'll have some more legal certainty that it can also be understood by smaller companies and not only by big companies. And I think, maybe Alex mentioned, we are talking about, to a large extent, commercial data, business to business. Can we actually talk about different levels of sensitivity? For example, in the SEC solution would maybe be a way to go, and not only get stuck in personal data, non-personal data in a mail, for example. We need to read the data that we actually are using in daily business. So I would say EU and US, if we can't find a solution there, then at least 94 of all the companies that transfer data back and forward between Europe and US are in trouble. So count on the support from the businesses. Remember, this is not a digital issue. This is an issue for car manufacturers, for health companies, for financial services, for professional services. So it is the key to how to create the growth across the continents and the key to the future trade and value creation. So count on us 200% to tap in there and to help you with finding those solutions. For us, it's daily life, and we know it's legal complexity, but for us, it's also really bringing the benefits of the digital decade to our citizens and to our businesses. Thank you so much for taking the time, Alex, Bruno, Irina, Jussi. It's been a great honor listening to you, and I put my trust, I put it in the top, and I'm certain that we will find a good solution. I put my trust in you. Thank you so much.
Thank you, Cecilia. I'd like to echo Cecilia's thanks to all our panelists. Thank you so much for sharing your time with us. I'd now like to invite all our viewers to join the networking area where you can be paired up with a fellow delegate to discuss what you just heard. And that networking area is going to be open for the next 30 minutes. Otherwise, thank you all for listening and have a wonderful rest of your day.